Thank you for joining this episode of our webinar series on best practices in eDiscovery. Today's session is focused on trends in eDiscovery that are impacting litigation in 2020 and beyond. We've got a couple of amazing guest speakers joining us today, and I'm really excited about today's session. My name is Jeff Fugit. I head up sales and marketing for Lexby, and I'll be the moderator for today's event. I hope all of you joining us today are healthy, free of COVID-19, and out of harm's way. And with that, we've got a lot of information to cover, so I'll get through the introductions quickly, share with you some trends that we're seeing here at Lexby, and then turn it over to our friends from Sidley Austin to present on eDiscovery trends that they're seeing. A little bit about our webinars. Our webinars take place monthly and cover a variety of relevant eDiscovery topics, trends, best practices, and strategies. We have almost 10,000 webinar participants annually, and we've got limited seating, so be sure to register early for the sessions that are of interest to you. If you have technical issues or questions, please email webinars@lexby.com and we'll address them right away. Our webinars are available online at lexby.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexby.com. To be notified of future live and on-demand events, please email us at webinars@lexby.com or follow us on LinkedIn. So a little bit about Lexby. Based in Austin, Texas, we provide a highly affordable cloud-based eDiscovery platform and services. We specialize in equipping organizations with an eDiscovery solution that gives them full control over the eDiscovery process, DIY capabilities, and very fast performance. We're the industry's most affordable and full-featured DIY cloud-based eDiscovery platform. We're the industry's fastest eDiscovery processing and document review platform. We deliver the industry's fastest return on investment per a study that was done by G2 Crowd. We have a team of experienced eDiscovery specialists and expert consultants who are all ACED certified and are standing by to assist clients on a moment's notice should they need it. But the platform is designed to be DIY, so you can do everything you need in the platform on your own. If you'd like a demonstration of our platform, simply email us at sales@lexby.com and we'll get that scheduled for you. As I mentioned, we've got two guest speakers joining us today. The first is Robert Keeling. Robert's been a friend of Lexby for a few years now. He's an incredible litigator whose practice includes a special focus on electronic discovery matters. He represents both plaintiffs and defendants in complex civil litigation throughout the nation and conducts internal investigations in the United States and throughout the world. Robert handles a wide variety of commercial disputes in state and federal court. He is experienced in multi-district litigation, False Claims Act litigation, commercial litigation, securities class actions, contract disputes, RICO and fraud actions, insurance coverage litigation, and many other types of cases. Robert is a co-chair of the firm's eDiscovery task force. He is experienced with technology-assisted review, predictive coding, and other applications that can enable clients to significantly reduce eDiscovery costs while maintaining the defensibility of the review. Joining Robert is Ray Mangum, an associate at Sidley Austin. Ray represents clients in a variety of government investigations and commercial disputes with a particular focus on matters involving complex data analytics and eDiscovery issues. A former computer science major and software developer, Ray has successfully applied technology-assisted review processes, including predictive coding and other machine learning techniques in a wide range of matters. His experience also includes analyzing large data sets to develop statistically backed legal arguments. So before I turn it over to Robert and Ray, I'm going to walk through some of the trends that we're seeing in eDiscovery. I'll also be asking for your participation and some polling questions to help set the stage for our guest speakers. All right, so the view from Lexby, I'm quickly going to cover ESI growth acceleration, enterprise data governance evolution, the growth in cloud-based eDiscovery, technology-enabled DIY eDiscovery, and then how we're seeing dramatically lower eDiscovery costs. So this topic is covered a fair amount, and we've covered it in previous sessions, and everyone understands that data is growing rapidly and there are emerging sources. However, there are some really important points that I'd like to make about this growth that can directly impact your matters. So ESI growth is targeted to hit 175 zettabytes by 2025, as shown in the chart from Data Age and Seagate. However, I really think it's going to surpass 180 zettabytes. So what's driving this growth? Well, there are several trends that are fueling this exponential growth, and here's a sampling of that. The growth of collaboration apps. So this is incredibly strong. Microsoft Teams and Slack are two of the leading platforms, but there are several. The entire collaboration category is expected to grow at north of 10% annually and achieve a 45 billion revenue milestone by 2025. This will likely accelerate since collaboration apps are typically cloud-based and support a mobile-connected workforce. And given what we're seeing with the COVID-19 crisis, collaboration apps are likely to be adopted at higher levels. SMS and instant messaging, also supported with the collaboration apps, has far surpassed email in terms of growth and quantity. You'll find thousands of apps that support instant messaging on mobile devices, and millennials actually prefer instant messaging over email and give it a higher trust level. So when you're conducting custodian interviews, it's imperative to assess the quality and character and demographic of the custodians to really understand, what should be included in your ESI agreement. Enterprise digital transformation is also driving this growth. It is predominantly the use of software, machine learning, and artificial intelligence to deliver process efficiencies, transformative business benefits that lead to competitive advantages. This can mean the utilization of application program interfaces or APIs that could stitch together several software components that are owned by different companies and hosted by different companies. Functions of APIs often add new data to the mix. We also continue to see strong growth in video and audio recordings, and this ties into the next bullet around IoT or Internet of Things data. Huge growth in the Internet of Things devices and data. The Amazon Echo that you see on the right is an example of an IoT device that also has an AI virtual assistant in Alexa. Virtual assistants are interesting from the standpoint that they often capture audio recordings. And if you're dealing with a labor and employment matter, think about the importance of an audio recording of a termination or some other activity. Amazon has been subpoenaed countless times for Alexa recordings, many for criminal investigations. But Amazon, Google, and Apple all have virtual assistants, but so do companies like Samsung. So it's important to be aware of, what kind of devices and brands of devices that the custodians are utilizing, and do they automatically come with a virtual assistant that's enabled. Another factor in the growth of the data sphere is the increase in file size. So we're now living in an HD world with 3D and HD imaging. Very high resolution and high fidelity recordings are a function of advanced imaging technologies as well as broadband networks that are capable of transmitting the files of this size. And the reason this is important because your eDiscovery platform has to have high performance scalable processing and storage in order to handle these file types. We see a lot of these in healthcare, as the image on the bottom right depicts. We will also continue to see expansion of ESI from established sources like email. Email is continuing to grow at approximately 5% annually. And it's really amazing to think about how long smartphones have been around, but they continue to evolve, have incredibly powerful processors, huge amounts of storage. And new apps come out each year, and data is more portable than ever. All of that factors into what we call shadow IT, which consists of applications, devices, and capabilities that are not sanctioned by the enterprise, but find their way onto enterprise networks. Sometimes this is due to a bring your own device policy that allows employees to bring their own devices. It's incredibly easy to download a file onto a personal mobile device from a corporate email account and use a personal email account, Dropbox, or one of the thousands of apps that allow porting that data elsewhere. So all of that's important to take into consideration. While the growth is expected, the fragmentation and expansion of sources is what really causes significant challenges. First, you need to understand what the ESI landscape looks like for your matters. Then you've got to deal with the issues of, is the ESI relevant to claims, to the defense, and is it proportional? Fortunately, there are some tools that you can use to navigate these issues. Utilizing a data map can be a huge help in gaining visibility into the ESI landscape. We had a webinar on data mapping previously, and we've got another one on the calendar, so watch for that in your inbox. Secondly, negotiating an effective ESI agreement is essential. We've got a sample ESI agreement in a recorded webinar that we did on this topic, and we're happy to share that with you. And this leads me to our first polling question. Would you like to receive the Lexby sample ESI agreement? And while you're answering that, I'll thank you for participating in our polling questions today. All right, I'll go ahead and close that poll. And now I'll move on to the next trend that we're seeing. And the next trend that we're dealing with in eDiscovery is enterprise data governance and the controls that enterprises are putting in place to handle their data and to try and mitigate some of the issues that they're experiencing. This has largely been driven by regulations intended to protect consumers from data breaches and other nefarious activities. Almost all 50 states have some form of data privacy regulations, including the more recent California Consumer Privacy Act. You also have GDPR in the EU. Most people are aware of that. And at some point in the future, we'll likely see a US federal regulation governing data privacy. The Ponemon Institute tracks the cost of data breaches, and as you can see, in 2019, it was running approximately $150 a record and $3.9 million on average per breach. So enterprises are getting more mature and trying to mitigate their risks by putting controls in place to better manage customer data. This includes defining data creators, data users, data owners, and data administration. It's important to understand what this looks like in order to know where the SI resides. Are there backups or archives? Could there be potential hidden repositories like we talked about with BYOD or in the cloud? I recently spoke to the CIO of a very large semiconductor company, and he said that employees are not allowed to keep email past 90 days. Where previously employees used email as a storage system. Slack and Google Hangouts and Microsoft Teams have similar settings, and more enterprises will be implementing data governance policies that will likely impact your eDiscovery efforts. So you need to make sure to take those into consideration. We're also seeing huge growth in cloud-based eDiscovery solutions, and it really should come as no surprise given our current environment. But at Lexby, we've experienced very high demand and growth. Relativity was a little late to the game with Relativity 1, but they're now in the cloud. We're seeing many law firms and enterprises transition from on-prem based solutions to the cloud. And with COVID-19 and needing to have a remote legal team, with a cloud-based solution, you can have anytime, anywhere access to your matter simply through a browser and accessing your cloud-based eDiscovery solution. We're also seeing many more virtual law firms and legal teams because of cloud-based legal tech solutions. Not only does it require minimal IT investment, since most of these solutions are browser-based, as I mentioned, but they also deliver the lowest cost for processing and storage. Another benefit that also reduces costs is that some cloud-based platforms like Lexby enable DIY eDiscovery. Lawyers and paralegals can easily work in these platforms with a modern user interface. Therefore, they don't have to outsource to costly third parties, and they can maintain control over their matters. Lastly, I'll mention that the majority of cloud-based eDiscovery platforms have better cybersecurity than most law firms. I see a lot of business email compromise with law firms, as well as other breaches. We utilize advanced AI threat mitigation solutions, robust encryption, multi-factor authentication, and a zero trust framework to help mitigate cyber threats. The next trend that we're seeing is DIY eDiscovery. Lawyers and paralegals are becoming much more tech savvy. The technology is becoming much more user-friendly, and we're seeing solutions that are fully integrated and don't require multiple point solutions. We're seeing more lawyers like Robert and Ray managing the entire eDiscovery reference model process from beginning to end. And many of the advanced technologies now have simple interfaces that make them easy to utilize as well. Lastly, we're seeing eDiscovery costs coming down significantly. We're seeing insurance companies push back on premium priced eDiscovery solutions. TAR is now integrated with a lot of platforms, and for some, no longer requires an additional fee. User fees are going away. The power of the cloud and driving down costs has driven a monumental shift in the eDiscovery landscape. Relativity's go-to-market strategy initially was to use resellers. They notified resellers a couple of years ago that they were going to start selling direct, and most of the cloud service providers sell direct. This is eliminating the middlemen and driving down costs. I think we'll continue to see a disintermediation of the resellers. Finally, while we're continuing to see an increase in data, we're seeing the per gig market rate continue to drop. So I think all of that factors into continuing to see eDiscovery costs come down. And with that, I'll ask one more polling question before handing it over to Robert Keeling and Ray Mangum. And that is, which eDiscovery trend do you see impacting your firm the most? ESI growth acceleration, enterprise data governance evolution, growth in cloud-based eDiscovery, technology-enabled DIY eDiscovery, or dramatically lower eDiscovery costs? All right. And while you're answering that, we will transition over to Robert Keeling and Ray Mangum.
Thank you, Jeff. As mentioned, we are going to discuss today some eDiscovery trends for 2020 and going forward, which include some of our experience about the preceding year that we just finished in 2019, and what we are really seeing in the industry and how those trends affect not only companies, but also outside counsel and service providers alike. So as far as an agenda today, we're going to cover a number of topics and really discuss kind of what we are seeing in each topic with each issue and how that may impact kind of going forward with that particular item. And so really when we think of eDiscovery trends, really more than anything, as far as what is going to happen in the years ahead, one trend stands out above all others. And so really the big trend in eDiscovery is that it continues to emerge as an industry, as a profession, and as an area of law. And I really can't emphasize this enough, how important this is, because what we had been hearing maybe 4 or 5 years ago is that kind of eDiscovery was flattening out, that we kind of covered all the relevant topics. And really what we're seeing is nothing further could be from the truth. Really, now all discovery is eDiscovery. And I think that has important implications for all different kinds of areas of law. And what it means is not only is eDiscovery growing, but I strongly believe that it will continue to grow. And largely as a consequence of really the staggering growth and diversification of data that we're seeing in the business world. Not just the volume, but kind of the variety and different types of data that really all companies that we're working with now are experiencing. And more data means more facts. Now, obviously, good lawyering has always required, an understanding of the facts in a particular case. But here, when you're dealing with, potentially hundreds of thousands or millions of documents, multi-millions of documents, you have exponentially more facts now than we ever did before. But not all of those facts are relevant or important. Maybe the number of really key facts, in my experience, has stayed relatively constant over time. But what you have now is, okay, the facts, the individual needles, the number of needles as far as key facts are the same, but the haystack is much, much bigger. And so when you kind of think about understanding your case from what is really important, when you're dealing with millions of data points, kind of this task about finding those needles has never been more daunting. And really as a result, what we're seeing is kind of eDiscovery is becoming increasingly specialized in order to find and identify those facts at really every level, from collection to analysis, processing, review, the whole EDRM. And those with the skills to take kind of these mountains of data and identify what is actually important, they're now at a competitive advantage, and a competitive advantage in a particular case. And it's really bringing about some kind of important changes. So one, as it says here, more and more companies are building out professionalized eDiscovery departments. Now, this was certainly true for many years now with some of the most largest companies or companies who are more in regulated industries. But what we're seeing is this is a trend that is only continuing, and now many companies, including mid-sized companies, either have dedicated eDiscovery professionals or at a minimum have in-house counsel who have eDiscovery as part of one of their job responsibilities. And this has really some important consequences for kind of eDiscovery practitioners and outside counsel and service providers, which is dedicated eDiscovery professionals who are in-house within companies. They bring really an increased level of professionalism to the handling of eDiscovery. And what we're seeing is they ask a lot of very good questions. And to answer those questions require not only a kind of an understanding of kind of the changing legal landscape, but also an understanding of the changing technological landscape. Because that could have a lot of importance, one, for particular cases, right? Because what people throw around words like reasonableness or proportional, but proportionality is a moving target sometimes. Certainly it can feel like that depending upon the particular case. And so deciding what to do in one case and what is reasonable in one case may not be reasonable in another case. And what we're seeing then is this is resulting not only on a case-by-case basis for companies, including in-house counsel, reaching out for advice on how to handle, but more higher level, on an enterprise level, in-house counsel are getting very sophisticated as far as questions to ask, as far as the company itself and how to handle eDiscovery from a corporate level, whether that's policies, procedures, practices, and bringing increased scrutiny to eDiscovery decisions. We're seeing this either with outside counsel guidelines, centralizing, standardizing relationships with eDiscovery vendors, for example, and really kind of focusing in and giving value to outside counsel service providers who can bring a higher level of expertise and judgment to different matters. And I think this is something that will only continue, right? What are some of the things that you're seeing?
This next item talks about something that you touched on, which is, of course, we know there's more data, but the data that we're seeing now is different. For a long time, to me, eDiscovery felt like a hard problem, but a fairly narrow problem, which was how do you narrow down an increasingly growing volume of emails, the vast majority of which are irrelevant to any particular matter. So in this view of eDiscovery, it was common for people to look at eDiscovery as a cost center. And as we all know, there's been rapid technological progress in this area as well. Machine learning text classification algorithms, which we sometimes call technology-assisted review, or predictive coding, have truly been game-changing in this regard. But increasingly, eDiscovery is no longer just about email. People are increasingly communicating in new and diverse ways, including social media and a wide variety of mobile messaging applications. And for a time, that was mostly limited to their personal communication. But more and more, those apps and their analogs are making their way to the enterprise. So ephemeral messaging, encrypted apps, work collaboration sites, those are all becoming increasingly important when collecting from companies. And
being asked and being requested by plaintiffs' attorneys and regulators alike.
Yeah, and especially in the litigation context and the government investigations context, the challenge there is not going to be just how do we deal with these new data sources from a technological standpoint? How do we process them? How do we make them available for review? But how do we take these new data sources and all the old data sources, including email, and how do we weave those together, extract the key facts, and make the best possible arguments for our clients?
And that has some important implications when you think about the different kinds of data, but how those different kinds of data interact with companies' information governance systems. So you can see on this chart about value economics and the like, that there's a lot going on in this chart. But at a basic level, what it shows is the value of data tends to drop dramatically in a very short amount of time. Somewhat counterintuitively, the cost of the data does not as much as you may think it does. Because what we see is, the cost of storage is going down dramatically. But despite the cost of storage going down, we see IT costs from a company continuing to rise pretty steadily. And how this is important is when you have an actual legal matter, a lot of times, and really more and more, the data that you're collecting has no business value to the company, especially if the company has poor information governance systems in place. And a lot of times, the data isn't even that relevant for the case, right? It might have a lot of documents in there that are what I call technically responsive. You have like these doc requests that start with all documents related to product or what have you. So yeah, you're going to find a lot of documents in there that are technically responsive to that request, but very few of these documents are actually probative to the case, and they have no business value. So it really just results in a lot of needless costs in the collection, processing, review, and production of this data that isn't really helping anybody. And by far the best way to minimize this cost is through effective information governance systems that can really reduce the amount of this kind of data that has no business value, such that really the only data that should be subject and to being available in a particular case is data that offers some value to the business. And what we're seeing is more and more companies are recognizing this and working on instituting effective information governance programs.
Okay, this next one is about legal hold management, which I think is a really big opportunity for a lot of companies. Improving the management of the litigation hold process in particular is a great starting point for companies that want to make improvements to their existing legal hold systems. So for medium to large companies in particular, you can very easily end up in a situation where you have overlapping legal holds. If the legal holds aren't tailored or if they're overbroad, this can result in data effectively being permanently on hold, because by the time one hold rolls off, the data is then subject to at least one other additional hold. And the first step really for getting a handle on this is to have a standardized legal hold system in place, and that includes dedicated legal hold management software. There are a number of options out there that can help you track your legal holds and institute your legal holds. And you also want to have the process for doing this well understood and well documented. And that documented, well understood process will then give you something that you can iterate on and make continuous improvements to. In addition, tracking the legal holds will allow you to have metrics in place that can show you where you were before and where you were after, including potentially being able to show cost savings, which is often the most effective way to have change within an organization. One reason why I think that legal holds represent such an opportunity for companies is because the rules have changed, and they literally have changed. It's been 4 years now since the 2015 amendment, including to Rule 37E of the Federal Rules of Civil Procedure, which made it clear that the principle of proportionality applies to the preservation of electronically stored information. So a party now, it's clear, must only take reasonable steps to preserve data, and perfection is not required. And moreover, we have 4 years now of subsequent case law applying Rule 37E, and that case law largely makes clear that the new rule has real teeth. Yet what we see is that many companies, and are often seeing too late, many companies are continuing to issue legal holds that are far too broad, in some cases placing even the entire company on hold. And even those companies that have changed the way they issue legal holds to make them more proportional often have a backlog of legacy legal holds that are far broader than they would be if those same companies were to put the hold in place today. So in this area, what we encourage companies to do is to think hard about your legal hold process, to take a proportional approach to instituting your legal holds. Avoid placing the entire company or entire departments on hold. Instead, you want to think about who in the organization is really likely to have relevant data. Of course, sometimes there's something out there, you know that it's important and you have to act quickly to preserve it. In those cases, you absolutely should do so. But a lot of the time, the best approach is to start with a fairly narrow set of custodians data sources that you know are likely to have responsive information, and then allow your legal hold to branch out and widen over time as you learn more and more about the matter. Finally, having a legal hold system in place and having these metrics, having this tracking in place will allow you to start to look at your legal holds at the organization level. So you're looking across matters and not just in the context of a single case. And from there, you can often see patterns and trends that will allow you to continue to improve your legal hold process.
And so when you think about other trends that we're seeing, I don't think it'll be a surprise to anyone to know that we are seeing particular emphasis around the cloud. So as our various clients' data has moved to the cloud, it becomes clear that eDiscovery, at least in some way, will need to move with it. And look, we obviously, data is moving to the cloud because there are a lot of benefits to that from a business perspective. Obviously, the data becomes centralized. There's a lot of cost savings typically that entails with moving to the cloud. And, you know, we are seeing from an eDiscovery point of view, cloud email providers are improving their kind of eDiscovery tools that come with cloud applications. But that's not true across all cloud providers, right? Not every cloud provider has robust eDiscovery export capabilities. And so depending upon the application, it may be difficult to get data out in a format that is kind of readily usable from an eDiscovery perspective. And also you combine that with privacy laws, both in the United States with the California Consumer Protection Act that was just passed and abroad, that obviously make collecting data from cloud-based sources challenging from a privacy perspective, especially in cross-border matters. And in our experience, you have mobile devices whom either a bulk or the vast vast majority of the data from individual apps may be stored not on the device itself, but in the cloud, which makes traditional collection techniques such as forensic copying and the like an imperfect way to obtain data that's on a mobile device. And now obviously it's something that I think may continue to improve from a logistics standpoint, but at the same time we'll be faced with other challenges as well, such as terminal messaging that Ray mentioned earlier. So it is going to be a continuing challenge for eDiscovery practitioners.
Next one is predictive coding, which is not a new topic, of course. In fact, that's sort of the point of this one, is that predictive coding has really come down to earth. Predictive coding is mainstream and in a lot of large matters. It's predictive coding algorithms are baked into the major platforms now, and what I've seen is that the views have finally seemed to have meaningfully shifted on this, so that there's not the same skepticism from sophisticated parties and from government investigators as to using predictive coding. In fact, when you're dealing with truly large cases, it doesn't even seem to be a question about whether you're going to use predictive coding, but instead how it's going to be used. And that increased comfort with predictive coding have led to, as well as decreased cost of the tools and improvements in the tools themselves, have really allowed us to make predictive coding the default approach in all but the simplest or smallest matters. That said, I really think that predictive coding is really just the beginning, not the end, of how machine learning, or AI, if you want to call it that, will be used in the legal space. These days, in a wide range of cases, we are regularly using predictive coding and other advanced analytics tools to, of course, exclude irrelevant documents, but also to prioritize our review of the documents that we do review. We think search terms sometimes have some people have negative opinions about search terms in the era of predictive coding. We think that search terms continue to be appropriate in many cases, especially where search terms can be applied at the collection step to reduce the volume of data that's collected and processed. But we also think that predictive models can be used in other ways, including being an effective check on human-level reviewers. For example, it can be helpful to look at instances where the human reviewer and the model diverge sharply. That might be a set of documents that you want to look at on a second-level review. And in the coming years, we expect to see continued improvement in employing multiple models within a single case, such as multiple kinds of responsiveness models, but also having a key docs model, a privilege model, and other kinds of text classification models.
So another big issue that we've seen, and I think we'll continue to see, is the emergence of structured data, and really how structured data is going to be the next frontier in eDiscovery. Because what we've seen obviously is our various workflows, models, including predictive coding models and tools and the like, grew out of a world that was focused on email. But these tools tend not to be as effective when dealing with structured data, whether it's relational databases or other tabular data sources, such as CSVs, and even really large Excel files. And often this kind of data needs to be analyzed rather than reviewed. And I think that's an important distinction here, because analyzing the data often takes kind of specialized skills and sometimes specialized programs or technology to digest the data. And this is an area where I think kind of traditional processing review tools will need to play catch up. But it's incredibly important because structured data, the data within a company, can be powerful evidence for a particular case. And it's separate and apart from, the email chatter back and forth, so much of which is just distracting or not actually relevant. But more and more, what's important to a company is the data. And presenting that data can be really case determinative. And too often, I think practitioners kind of try and avoid structured data because they don't understand it, frankly. And that many times can lead to important evidence for your case that is very positive and favorable to your client being missed. And so I think more and more we will see practitioners being able to kind of use this structured data and take it and to present, in as affirmative evidence in a case in chief.
Yeah, Robert, I think this is another area where we're starting to see sophisticated requesting parties ask for this early on in the matter, and it's going to become something of a battle about who can analyze and make the strongest arguments off of this kind of structured data. That's right. The next one is a familiar topic, which is the attorney-client privilege and the word product doctrine. I really think that this area, it's long been true, but it remains the hardest part of review and production. I think it's a difficult problem because this is an area where even human attorneys frequently disagree on whether a document should be treated as privileged. And those privileged decisions, often the reason that it's so difficult to make a privilege call isn't really about the law of the particular privilege at issue. It's because the relevant facts just aren't reflected on the face of the document itself, which could be from years ago. So in light of the difficulty in being able to determine whether a document is or isn't privileged, and there's no, I don't see anything on the horizon that is really going to make this a solved problem in the next couple of years. I think we're still going to have a lot of close calls to make, and for all those reasons, the 502D clawback orders have now become sort of conventional wisdom, and in almost any matter, the parties should be, if you're going to be a producing party, should be strongly considering getting a 502D order. We've also, on the privilege front, the normal way, of course, of dealing with asserting privilege is to do so in the form of a privilege log. We have seen some openness from the government and other requesting parties to doing alternatives to the traditional privilege log. Everyone understands or seems to understand it now that that is an incredibly burdensome process. In particular, I think I've seen some increased receptiveness to what we call objective logs or metadata logs. This is where you export out a tabular summary based on the objective metadata that is in your, it was extracted by your processing tool and is in your review platform. There's also some interest, I think, in so-called categorical logs where you group documents into categories and then give some additional information such as the number of documents in that category and the to from CC if they're emails, so that you can say everyone who saw the documents in that category. And one final tip on these kinds of alternative logs is that you can frequently do the alternative log and get buy-in on the alternative log by agreeing to produce traditional log entries for those that the receiving party request, or at least a reasonable number of requests, so that if there's any that they would like a traditional log format, they can still get that, but you don't have to do that in advance prior to producing your log.
So next issue really relates to kind of analytics of data. Now, part of this relates to what I was talking about before with respect to big data, where we have kind of structured data sources, and more how that's playing a determining factor as far as liability or damages. Where we see this is in cases, for example, centered around transactional data over a period of years. And kind of investing in the analysis of that data to make data-driven arguments can be really important as far as affecting how that case comes out, win or lose, right? And there's other aspects for big data analytics where we can expect the use of machine learning. This is not so much what we're seeing now. Typically, you see with big data and structured data, some type of report out and then an analysis on the report. That will definitely continue. But companies are using sophisticated algorithms and machine learning for their own analysis for business purposes. And I think we will see the use of these types of machine learning approaches being used on big data for cases, for litigations, for white-collar matters, for kind of effective and building effective presentation. We're also seeing kind of thinking about analytics is new ways to present data or really organize data, right? So traditionally, when you think about your facts and how do you organize those facts, well, most case teams would use Excel or a word table or something to that effect where they present, you know, the order of events or chronology or however you want it. What we're seeing now, though, is a number of companies have kind of built a better mousetrap in this respect and have crafted analytical tools that let you kind of analyze, sort, search your facts, your key dates, your key people, key events, things like that, and be able to kind of mix and match in a really effective way. And it really increases a lot of efficiencies into the kind of traditional digesting of information. And I think we're only going to see those, one, be adopted by more and more case teams, but two, increase abilities as we go forward.
Just a quick one here on what we call case closure. So, so once you settle a matter, obtain a judgment, or the threat of litigation goes away, it can be be easy to feel like the case is over. But there's often, at least from an eDiscovery standpoint, some additional cleanup that needs to be performed. So you don't want to be in a rush to immediately necessarily get rid of the data that you've collected and that is exists as a result of the litigation, and to lift your legal holds, because you often have to consider ancillary threats such as related spinoff litigation, or sometimes it's not clear. There's not always such a bright line as to when the matter is over. So there is a concern about acting too quickly, but most of the time what we see is that companies don't act soon enough, that they don't dispose of the old data when it was no longer subject to any threat of anticipated litigation before the next new litigation arises, and they still have data from the past litigation that was never disposed of. And this can create a never-ending cycle where the company never returns to its normal information governance practices. So one tip in this regard is that once a matter seems to be over, you can set monthly check-ins to assess whether or not there's any additional litigation that's reasonably anticipated. If not, whether you want to lift your legal holds. If you lift your legal holds for the company, whether you retain a separate copy of the data that was produced in the litigation, and to sort of hold yourself and to account on making sure that all the necessary eDiscovery cleanup at the end of a matter is actually carried out.
So another trend that we have seen for many years, and But I think what we're seeing though now is a greater focus on it, is really addressing legacy data, right? So this has been a kind of an ongoing struggle for companies, especially big companies. It's so often on the back burner. And you have all this legacy data. It's not pursuant to a legal hold. There's no legal hold over the data. It's just there. But remediating this data really represents a big opportunity for many companies. One thing I want to focus on is the most legacy of legacy data, which is surprisingly, or perhaps not surprisingly, many companies have lots of paper documents. And really addressing these historical kind of paper document corpuses can represent big cost savings to a company, and also help kind of broadly assist with information governance goals. But Ray and I have dealt with a number of companies who have had boxes of documents in the hundreds of thousands, and it's important to kind of address this type of data source, and it can really have immediate impact with respect to storage, right? But have long-term impact with respect to getting rid of documents that just don't have any value and are just there, and really nobody knows what's in these boxes too often. So, one problem is, well, how do we address this? And this can be true for paper documents. It can be true for, we've seen hundreds and hundreds of hard drives or backup tapes, or, these different collections of data sources, including, old, almost forgotten about shared drives. Increasingly, we see companies take a statistical approach to this problem, reviewing samples, documenting the results, and proceeding from there with remediation steps. And this can give companies really peace of mind, but also assist with the defensibility of the remediation. But from an internal corporate point of view, sampling also assists with kind of the internal approvals that are needed to kind of address these larger legacy document collections. So it really is something that should be addressed and should kind of be taken off the back burner.
Yeah, I just wanted to address one thing that we often hear, which concerns the electronic data storage, is that storage is cheap. And in one sense, that's true. I mean, the cost of storing a gigabyte of data has just steadily decreased. Everyone is familiar with the fact that they can go out and buy a thumb drive that has far more data on it these days for a couple of bucks than their first computer had. But in another sense, storage is not cheap, because the total volume of data being stored electronically in an organization is increasing even more rapidly than the decrease in storage costs per gigabyte. And that's especially true if you factor in the IT infrastructure costs, the IT personnel, the servers, the cloud-based expertise if you're storing data in the cloud. And so according to several estimates, the total cost of storage in an organization is actually increasing rather than decreasing. And when you're trying to make that case for why it's important to have effective information governance systems in place, you can make the arguments that Robert touched on earlier, which is that this data will not be cheap if you have to process it all and pay attorneys to review it, and the consequence of litigation. But there's also a straightforward argument that on the whole, the total cost of electronic data storage at the organization level is actually increasing, not decreasing.
All right, so just a few more things, really few final observations. One, I touched on it briefly, but privacy is really continuing to increase in importance. And I think one trend is that privacy will not be separate from civil discovery. Ray and I actually have an article that was published by the Sedona Conference Journal called The Burden of Privacy and Discovery that really looks at the intersection of privacy on the one hand and civil discovery on the other, and kind of makes a lot of observations about how privacy and reviewing documents for privacy implications can impact whether a particular request is burdensome and proportional or not. Second, non-party discovery, whether in Rule 45 or in the kind of law enforcement context with third-party CIDs and the like, it continues to be extremely burdensome. There is some helpful guidance from, for example, the Sedona Conference that just recently came out in more finalized fashion, suggesting, helpfully, I think, that non-parties ordinarily need not implement a legal hold when they are a true non-party. We think this is going to continue to be an area of interest for many companies, kind of how to handle Rule 45 requests, when and whether to issue legal holds and the like. Finally, the continued use of machine learning in the corporate environment for business purposes is raising some pretty interesting questions. Companies are retaining large amounts of data to train machine learning models, but often, that data can be or is, whether it's restructured or transformed or de-identified, right? Thus making it in many ways kind of different data. So when data becomes de-identified and transformed in some way, it becomes a significant question about whether this data is the same data as was before, especially if the original data gets purged kind of in the normal business course. So in that sense, it becomes difficult to determine whether a particular data set is relevant or responsive to document requests. And I think that will be more important, increasingly important as going forward as the years continue. So with that, we can bring this session to a close, right, Ray?
I think we've covered it.
All right. So thank you all for joining. We hope this has been helpful and that you got a lot out of it. And we wish you the best of luck in your eDiscovery challenges going forward here in 2020. Thank you.
Thanks, Robert and Ray. That was a fascinating presentation, and I really appreciate your take on the eDiscovery trends that you're seeing in 2020. I'm going to share with you a little bit more about Lexby, and then we'll wrap up today's session. Lexby is uniquely positioned to help law firms and organizations that want to keep eDiscovery in-house, solve for the challenges of document-intensive matters, and embrace a DIY solution. We deliver an end-to-end cloud-based eDiscovery platform that is full-featured, DIY-enabled, infinitely scalable, and accessible from virtually any internet-connected device. We are located in the AWS cloud. With the Lexby eDiscovery platform, there are no user fees or case fees. The pricing is primarily based on the data in the platform. There are a few additional services like machine language translation and transcription that come with a few additional costs, but we're happy to provide you visibility into that. Lexby equips you with state-of-the-art technology that is simple to use, so you don't have to have dedicated IT support or litigation support professionals on staff in order to have advanced eDiscovery operations. Only Lexby equips you with the Uber index. So this is a highly advanced index that is comprised of native characters, OCR'd characters, and translated characters. Having native and OCR'd characters is very important when dealing with large document sets because there are several use cases that require both in order to assemble a complete data set containing the evidence and privileged documents in the platform and for those to be searchable. In addition to the Uber index, Lexby also equips you with advanced technologies that are instrumental in locating evidence as well as protecting privileged documents. The LexB eDiscovery platform includes technology-assisted review, email threading, near-dupe groupings, which I find particularly powerful, especially when dialogues cross communication modalities, sentiment analysis, cognitive image recognition, audio transcription, language translation, and much more. And just to give you an idea of the cost of LexB versus what you might see from a relativity reseller, here's an example. As you can see, the LexB eDiscovery platform is engineered for high efficiency eDiscovery. Processing is included in the hosting subscription versus having to pay a per gig fee from the reseller. There are no user fees for LexB versus the $95 per user per month in this example. Technology assisted reviews included with LexB versus a $30 per gig per month fee for the relativity reseller. Near duplication, email threading, and AI insights are all included with LexB. And our project management fees are less at $150 per hour versus $195 per hour. So LexB subscriptions start at $5 per gig per month. LexB also maintains a very strong cybersecurity posture to mitigate threats. We utilize AI to identify and eliminate threats before they can do harm. We have multi-factor authentication. We've passed an extensive application penetration test by IBM in 2019. And with that, I'll ask our last polling question. Would you like a demonstration of the LexB eDiscovery platform? We'll be making the following available to webinar attendees today. So you'll receive a recorded streaming version, MP3 podcasts, and PDF. Please let us know if you have any questions or comments about this webinar or suggestions for future topics. You will receive a survey at the end of today's session, and we greatly value your feedback. This webinar is part of the LexB eDiscovery webinar series. For notices of future live and on-demand webinars as part of the series, please email us at webinars@lexb.com or follow us on LinkedIn. And I'd like to thank Robert and Ray for their great presentation. And I'd like to thank all of you for attending our webinar session today. Stay healthy out there and watch your inbox for an invite to our next webinar on best practices in eDiscovery. Take care. Thank you for joining.